Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast. That is, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. I'm Paul Gigot here with James Toronto, and we're both of the Wall Street Journal, talking about the Supreme Court and the clash over ethics and interviews that Justice Samuel Alito granted to the Journal. We reported on. They were on the record, by the way. This was not some secret interview. He wanted to talk about these issues. And another issue the Democrats have raised in a letter last week to Chief Justice Roberts, asking the chief to disqualify Samuel Alito from hearing any challenges to congressional power to regulate the court, number one, if that became a case. And number two, asking the chief to disqualify Alito from hearing Moore v. U.S., which the court has agreed to hear in the coming term. That's a tax case. And the argument, James, is that, well, Mr. Rivkin, David Rivkin, who was your co-interviewer, co-author of the pieces, he's part of the legal group that represents the plaintiffs in Moore v. U.S. What do you make of that claim that he should recuse himself?
Well, it's a preposterous claim. Justices have social intercourse with lawyers before the court all the time. The Washington legal community is fairly small. Several justices attended Ted Olson's wedding when he was Solicitor General.
I was there.
Yes. And so the important point here is we did not discuss Moore versus U.S. with Justice Alito. Ruth Marcus of the Washington Post alleged that the litigants in this case had special access to Justice Alito, but that would have required their lawyer to discuss the case with Justice Alito, which would have been serious professional misconduct. We didn't discuss that case. We barely discussed any pending cases with Justice Alito. We mentioned the case in the piece only in a list of cases that the court will be hearing in the fall, and we added this disclosure in the interest of transparency.
That Rivkin represents.
That Rivkin represents the appellants, and then we got attacked for it.
Yeah, I mean, it was the right thing to do to disclose for transparency's sake that David Rivkin's role in the case. But if you are going to disqualify an appellate lawyer for saying nice things about some justice, basically you're going to disqualify 3/4 of the appellate bar.
Yeah. And on that letter, we should make the point that the Chief Justice has no authority to prevent Justice Alito from sitting on a case. The Chief Justice actually has very limited powers. He has certain administrative authority over the court, and he has the authority to assign the writing of the majority opinion when he is in the majority. Other than that, he's just another justice. He can't tell the associate justices what to do any more than if the president wrote a letter to Senate Majority Leader Chuck Schumer and said, you better make sure Senator Manchin votes yes on this bill. It would mean nothing. Senator Schumer has no such authority.
Well, the Democrats know this. I mean, they're not stupid. Certainly some of them are, but not these guys on the Judiciary Committee. They're very crafty in what they do. And the reason they've made this demand of Chief Justice Roberts, I think, is because they're just teeing it up. They think it will help their argument to have this ethics bill passed that includes these new demands for recusal and these new rules for recusal.
Well, the ethics bill isn't going to become law as long as Republicans control it.
My friend. Yes, as long as. That's a pretty big caveat.
Yeah. But, I mean, they are doing this for a variety of political reasons, including to stir up their political base. I would just note that 10 of the 11 Judiciary Committee Democrats signed this letter. The one who didn't was John Ossoff of Georgia, the only swing state Democrat on that committee. So that tells you something about the politics of this.
It does. And I agree with you. The law is not going to pass in this Congress. All Senate Republicans opposed it. But I think this is a more perilous situation than many people think. And the reason I say that is because what blocks this from happening now is control of the House. Republicans aren't going to vote for it, but they could lose the majority easily in 2024, and probably will. Second is the filibuster in the Senate. So all the Democrats need to do is maintain the White House in 2024 with Joe Biden, turn the 5 seats, 6 seats in the House to regain the House majority, and then gain 2 or 3 seats in the Senate, enough, and maybe only 1 if Joe Manchin is, 2 if Manchin is defeated, I guess. Sinema and Manchin are the 2 senators, Kirsten Sinema of Arizona, who have opposed overtly the filibuster change. But if they go and they get 2 or 3 more seats, enough to break the filibuster and then pass something by majority rule, I think this bill could pass.
Yeah, it could happen. Oddly enough, the Senate is probably the toughest of those 3 for the Democrats to hold.
But who knows? I mean, right now they have a 51-49 majority, probably lose the Manchin seat. But there's a lot else that is up in the air. And then it's not only just about 2024, but what about 2026 and 2028? I think, James, all of this is aimed at discrediting the court, to creating a public theme that somehow the court is a rogue body, a political body, and therefore it must be reined in by politicians. Yes, that's what they're doing. And I think this is very dangerous in my view. It is undermining the independence of the judiciary, essentially breaking the constitutional defined role that the founders put, which made the justices explicitly independent. It didn't use that word, but it gives them lifetime tenure for that purpose in mind. And it created the special Article 3, where the Supreme Court is expressly mentioned as not being a creature of Congress.
Yeah, it's probably the greatest peril to the court since 1937, when FDR and some of his Democrats in Congress tried to pack the court. That ultimately didn't get through an overwhelmingly Democratic Congress, but the parties are a lot more polarized now than they were then.
What do you think of the degree to which this will be a political issue in 2024?
Well, it could play both ways. I mean, you remember in 2018 when the Republicans lost the House, they won the Senate. And I think part of the reason they won the Senate was because of the way the Democrats had beaten up on Brett Kavanaugh. There were several Democratic seats from red states, Missouri and Indiana, that flipped. And there are a couple of Democratic seats from red states this year, or next year rather, Montana, Ohio, and West Virginia. West Virginia will probably go Republican. The other 2, I think, could. So it could go either way.
One of the questions that I have about all this is you would expect typically lawyers and the legal community to come to the defense of the Supreme Court and its independence, right? These are people who venerate the law. They make their living by it. They view it as an important part of the buttress, as a bulwark of our freedom. Where the hell is the American Bar Association? Where are the American Constitution Society and the other people who purport to believe in the rule of law, to defend the court?
The American Constitution Society is a liberal group that was set up as an alternative to the Federalist Society.
I know, but the point is that's its name, the American Constitution Society. They believe in it or are supposed to.
Sure. The American Bar Association, I mean, one of the points Alito made was he's speaking out because the organized bar hasn't been doing it. And I suppose the basic answer to that question is, like many of our institutions, they've been taken over by the left. They're either controlled by them or cowed by them. And so they've lost their sense of institutional norms.
And Alito told us that that was one of the reasons he said he was speaking out. That's one of the reasons he granted the interview, was to talk about some of these issues. I think that some of the other justices, including some of the liberals, need to speak up too, particularly on some of the issues like recusal. One question, and it's really a prudential one for the court and the justices, is to what extent should they come out themselves with some kind of new ethical standards that they would adhere to and a process by which they can, any questions about whether or not something they might do would violate those standards, you would have somebody who would be an advisor or something. Is that something the court should do as a way to essentially neutralize the attacks on ethics by the left?
Well, I think they grappled with that question and answered it in the letter that you mentioned, signed by all 9 justices. And I don't think there's any way to neutralize the attacks. I think if you give an inch here, the left will take a mile.
So you don't think that there's any way, if they gave ground, but let's say they created an advisory board of lower court judges, say the head of the Sixth Circuit, the chief judge of the Sixth Circuit, the chief judge of a couple of other circuits, and they said, if we have an issue of ethics, we will go to those judges and seek their counsel. They wouldn't, of course, be following they wouldn't have to take the advice, but they would be going there for counsel.
Well, the Judicial Conference already does some of this. They have committees that address these questions.
But not specifically in the case of a justice.
Well, except that the Judiciary Committee had a big so-called blockbuster hearings a couple of months ago because one member of one of these judicial conference committees from over a decade ago came forward and said he wasn't happy with the way it handled a complaint against Justice Thomas. And so the Judiciary Committee Democrats are making an issue of this now because Justice Thomas is in the majority. This has nothing to do with ethics. It's all a pretext.
So making that concession on ethics, any kind of concession, would be essentially conceding that there is some kind of case here on ethics, some kind of problem, when there really isn't. This is all just about politics, in your view.
Yeah, it's not only that there isn't a problem, it's that the claim that there is a problem is made in bad faith.
So you have no problems with the fact that all these stories about trips to Alaska on a private plane or things like that in ProPublica, the New York Times, the latest New York Times story is that Justice Thomas 20 years ago, more than 20 years ago, bought his RV that he and his wife take around the country from a billionaire. Somehow that doesn't bother you?
Well, there was a report in the Washington Post by Ruth Marcus in 1991 that said Justice Brennan, whom you mentioned earlier, who had just retired, had received cash gifts and a payoff of a loan from a real estate developer friend of his. And this was put on page 4 of the Washington Post. So if there's a problem with this, why wasn't it a problem 30 years ago? Why wasn't it a problem until there was a conservative majority of the court?
And your answer?
My answer is...
because it's now a conservative majority of the court.
Yes, the whole ethics hullabaloo is a pretext for attacking the conservative majority of the court.
Yeah, I tend to agree with you, James, that I think the court does abide by ethics rules, as you said, that are the canons of ethics. They do it voluntarily for the most part. There are some exceptions. They can accept money for teaching, for example, at courses. They could, until spring, accept private aircraft travel. Now that's been changed. They are supposed not to do that. They can accept money for books that they write, which, by the way, seems perfectly legitimate to me. So if you have those kinds of rules, which are pretty effective by and large, and by the way, nobody in any of these accusations has found any evidence that there has been any cases influenced by any of this, right? Which is the ultimate test of whether or not there's a violation of ethics.
Yeah. And when you think about how ethics have become the basis for political attacks, and not a lot more than that, this really feeds public cynicism about our institutions in general, not only the Supreme Court, but Congress and all the rest of it.
Yeah, so the left, which is purporting to care so much about norms and so much about our institutions, is in this case undermining a central institution that is the bulwark of our liberty. All right, James, thank you for coming in. Thank you all for listening. We're here every day on Potomac Watch, and we'll be here all week again. So thanks for listening. Hope to catch you tomorrow.